Thank you. Do we have a question from the audience, please?
Let me begin by saying appreciation to both of you for your respective histories in serving our government and being here for us to hear you today. I did hear a variance of opinion on the consideration of political affiliations and the impacts between the branches of government. And I want to go back to that and ask you, as you reflect on what's been happening in the state of Ohio for the past decade and more recently in the past few years, where we see issues such as building standards that demanded to be statewide uniform, the concealed carry, the residency, so many things that local government sees as demise of home rule. I'd ask you to reflect on this demise of home rule and how you feel you make decisions about that. And in short, is it time for another constitutional convention in your opinion? Thank you.
Judge Sikora.
Mayor, I appreciate that question. I understand where it's coming from as a former mayor. I'm very troubled by some of the decisions that have come both from our legislature and from our Supreme Court. I find it very interesting that the conservative argument always is let the local communities make the decisions, because the people in the local communities are better able to make the right decisions for the people, except when there are special interests who have invaded on the legislature and have convinced them to pass laws restricting that. And I think the list that you gave us certainly are representative of that. So I'm very troubled by the fact that the legislature can jump in and override the local community's ability to make laws. I think it's very important that we still have home rule. If it's in the Constitution, we should respect that. And I think that's another example of this court not exercising judicial restraint, but rather being very activist in some of their decisions.
Actually, I have a strong record in terms of home rule. I wrote one of the leading opinions on home rule involving the control and the regulation of manufactured homes within the territory, a case out of either, I believe, Akron or Canton, that reaffirmed and has been frequently cited as the home rule case. We've had several cases that have affirmed home rule in the recent years. One was involving the ability of Cincinnati to regulate the size of weapons that were brought into their territory. One was the ability of jurisdiction to control the speed limits within its jurisdiction. Those sometimes don't get as much attention as when there is a decision that finds under police powers the state, under our constitutional standards, has ability to set statewide standards, but they are still out there and they are very strong. I personally am a strong believer in the home rule principles of the Constitution, but we have to look at the entire state and we have to look at all of the cases and set the standards that come before us.
Thank you, Justice Stratton. The next question, please.
I want to go back to a question about running for judicial office and the cost of doing that. There's been a suggestion that, at least at the Supreme Court level, that there should be public funding of the candidates' campaigns so as to avoid the need for the candidates to do the fundraising. My question is whether, for both candidates, would you support that? Do you think the electorate is willing to support it? And would you be willing to forego doing private fundraising if public funding were available?
And Justice Stratton, why don't you had indicated a moment ago that you wanted to talk further about the New York Times. Why don't we expand both that question to include an opportunity for you to talk about the New York Times, and we'll give you 2 minutes to do both, and we'll then give you, Judge Sikora, 2 minutes as well.
Well, the New York Times article is much cited by the media, and it's cited for proving or establishing that there's a correlation between vote and contributions. It is actually, even though I benefited from the statistics, I still think it's a terribly flawed study because it looked at contributions from lawyers, found out that, that the justices voted 50-50, so it took all those figures out. And then it looked at different cases for different justices. For Judge O'Donnell, who got the worst rating, it only looked at 26 cases. He had decided thousands of cases by that point. You could pick any 26 cases and come up with any figures you want. So I suggest to you that is a very flawed study. But as to the issue of money and elections, actually the Supreme Court races are very, very small in comparison. We will be lucky if we raise $1 million us for our race. The governor's raised $14 million, Senator DeWine raised $17 million and lost. So it takes a lot more than money. It takes popular support, it takes getting your name out, it takes grassroots support, it takes a wide base of people. When you level the playing field and give each candidate a same amount of money, then sometimes you take away what is that base of support, and you might just give a name game a win. Somebody who has a strong name like a Brown may end up winning against a very qualified candidate when they have very bad qualifications or very poorly qualified, simply because the money is now equal. So I believe that the base of support still reflects what you have in the community, your reputation, your assessments by the bar, what people really want in a justice. And when you level the playing field, sometimes that takes all those key factors out. On the other hand, if we had public financing and I didn't have to go around the state raising money, I would be delighted. So there's good and bad to it.
Thank you, Justice Stratton. Judge Sikora.
Justice Stratton has said on a number of times that it doesn't really matter whether we have Democrats or Republicans on the bench, because when we put the robes on, you're not a Democrat or a Republican. And that's true. But when you get to the issue of fundraising, it's very clear that the people who contribute to the campaigns know who the Democrats are and who the Republicans are. And if you look at where the bulk of the money is coming from for the two Republican candidates, you'll see that most of it comes from insurance companies and big business and the Chamber of Commerce and the medical industry. The contributions for the two Democrats, as little as they are this year, come mostly from attorneys representing injured Ohioans, from labor organizations representing the average working man and woman, from the Democratic Party, and from grassroots Democratic organizations around the state. And that happens because people contributing to the campaigns of the various candidates believe that those candidates represent their philosophical views. That is represented in the decisions that come down. Justice Pfeiffer, in a dissent on the statute of repose case, said, "Today is a day of fulfilled expectations for insurance companies and manufacturers of defective, dangerous, or toxic products that cause injury to someone in Ohio. But this is a sad day for our Constitution and this court. And this is a tragic day for Ohioans who no longer have any assurance that their Constitution protects the rights they cherish." I think that sums up the difference between the philosophical approaches of the right and the progressive in this race. Oh, but on the issue of public funding, you know, that would be very nice if we didn't have to spend time and our campaigns didn't have to do that. My only concern would be that the independent groups still have a right to raise money and to sink as much as they want into a race. And as I mentioned before, the organization this year that has raised almost $1 million and is spending it on the two Republican candidates have certainly no restrictions on how much they can raise. So if we could somehow work around that, I think the idea of public funding might be a very good one.
I have a question while we're waiting for another question from the audience about the school funding cases. Those were probably some of the most important or high-profile decisions of the Ohio Supreme Court over the last few years. The court ruled on several occasions that the current system is unconstitutional, but to date the legislature and the governors haven't done anything to address that finding. So the question I have is then to each of you, either a current member of the court or a potential member of the court, why is it that the court didn't issue some kind of enforcement mechanism to ensure or to require the executive or the legislative branch, either individually or collectively, to address the court's finding? And I think, Judge Sikora, it's your turn first.
I don't know why the court didn't do something to enforce its decision, because not once, not twice, not 3 times, but 4 times, the Ohio Supreme Court ruled that the funding for our schools is unconstitutional. The Constitution requires a thorough and efficient system of public schools or common schools throughout the state, and the court found that the way that we finance the schools was inadequate to do that. But yet, it never did anything to enforce its decisions. And in fact, on the 4th time, it essentially said, well, you haven't done anything to remedy it, so we're just going to dismiss it and we're going to let you go do what you want to do. I think the Chief Justice spoke and said that he did that, or the court did that, because they didn't want to cause a constitutional crisis. Well, I think by finding the system unconstitutional, we already had a crisis. I would suggest to everybody listening that if a court found that something you or I did